Hi folks, my name is Greg McLawsen. I'm the Affidavit of Support lawyer. I represent green card holders in federal litigation to enforce the Affidavit of Support, and I serve as a consulting expert in family law cases when green card holders enforce the affidavit in the context of divorce proceedings. Today I wanted to talk about a recent example of how attorney fee awards work in these cases. This is not one of my lawsuits. This action was brought by attorney Ross Kinder in the northern part of Alabama, Federal District Court for the Northern Division. And it's a really strong example of how fee awards work in these cases, and a really good example of why sponsors are so much better off approaching these matters through good faith settlement negotiations rather than trying to defend lawsuits on highly technical grounds. That doesn't work. And when sponsors take that approach to lawsuits under the Affidavit of Support, they end up paying a huge amount in attorney fees. That money instead could have gone towards a settlement and gone towards the beneficiary of the Affidavit of Support rather than being plowed into litigation. So let's go through some of this. Again, this is the Belovich case in the Northern District of Alabama. And this matter has been litigated for years now. The original judgment in this matter was back in 2020. And Ross had done a good job of litigating this matter and had most of it resolved on summary judgment. So settlement negotiations in this case had totally failed, and Ross obtained a summary judgment order. That's a pre-trial, it's called a dispositive motion, that partially resolved the case and had achieved, I think it was about $25,000 in damages through a summary judgment award. The little bit of the case went on to a federal jury trial. And so get this, and we're talking about a full-blown federal jury trial. And the damages that ended up getting awarded in that federal jury trial were about $6,000. So all told, the amount that was actually in controversy in this case turned out to be about $30,000. Well, under the Immigration and Nationality Act, there is a fee provision. This is exclusively in favor of the green card holder, which means that if a sponsor successfully defends an Affidavit of Support lawsuit, they do not get their fees awarded. But I-864 plaintiffs are entitled to a fee award. So the Northern District of Alabama, following the entry of judgment in favor of the plaintiff, awarded Ross and his firm about $75,000 in fees. So here we already have $30,000 in terms of what was actually at stake in the lawsuit, in terms of what the beneficiary of the contract could recover, and then $75,000 in fees to go through all the expenses of enforcing that contract. Now, this is just to get to judgment. Then the defendants appealed that judgment up to the 11th Circuit Court of Appeals. The plaintiff responded to that appeal successfully. The 11th Circuit's decision in Belovich is one of several federal courts that have held that I-864 defendants have no ability to defend these lawsuits on the basis of contract law affirmative defenses. So one of the dynamics that was in this case, which you see all of the time, is that the plaintiff is asserting a narrow claim under the Immigration and Nationality Act. It's a very narrow cause of action, seeking damages equal to the difference between their income and 125% of the federal poverty guideline, because that's what's at issue in the Affidavit of Support. What sponsors often want to do is to greatly expand the scope of the federal litigation, because they're going to lose on that narrow contract issue. That issue turns on, was the Affidavit of Support signed? Yes, it was. Did the beneficiary achieve U.S. residency status? There's not going to be a question of that. And then the only other question is what the person's income was, because that determines the measure of damages in these cases. So Belovich is a good example of that. Ross, representing the plaintiff, was able on summary judgment to demonstrate most of what it was that the plaintiff was entitled to. Then there was a very narrow amount of damages that remained in contention, and there was some fact-finding in front of a federal jury about what the plaintiff's income had been, and then that returned an additional $6,000 in damages following the jury verdict. Well, that's all pretty narrow. We're just talking really about what the plaintiff's income is. Well, sponsors in these cases often want to make these cases into a broad referendum on, was the beneficiary a good person? And candidly, in the Belovich case, the answer is no. The plaintiff was not a good person and had engaged in all sort of conduct that the federal district court referred to correctly as despicable. But that's not relevant under the federal statute. The federal statute doesn't authorize the court to engage in a long, wide-ranging exploration of who's a good guy and who's a bad guy. The federal court also doesn't have jurisdiction to hear additional claims about what happened in a relationship and who was a good person and who was a bad person, and who was subjected to abuse and who, engaged in misconduct during a relationship. That's not what federal courts have authority to decide. So the defendant in this case lost at the district court level and then wanted on appeal to take another shot at making this defense that the marriage was never genuine to begin with, etc. The 11th Circuit said, no, that's not what these cases are about. You signed the Affidavit of Support contract, and so you are strictly liable to pay the support that's owed under the contract, regardless of whether the beneficiary is a good or bad person. So the 11th Circuit then remands the case back to the Northern District of Alabama, where the plaintiff's attorney is awarded another, let's make sure I have the figure right, I believe it's $45,000 in attorney fees. Make sure I have this right. This decision just came down today. $49,000. So we're talking about another $50,000 in fees. So at this point, 50 plus 75, so we're basically up to $125,000 in fees in this case, where there was basically $30,000 that had been in contention in terms of what was owed to the plaintiff. So this is a really strong example of the craziness of having sponsors plow a bunch of resources into spinning up federal court litigation over defending an affidavit of support responsibility. This thing could have been resolved years ago for a fraction of the cost. So the sponsor in this case effectively could have saved himself $125,000 by simply looking at the contract through the narrow lens of what the obligation is, that is to provide income equal to 125% of the poverty guideline. And what was at stake was about $30,000. So you could have spent $30,000 to live up to the plain obligation under the contract, or pay an additional $125,000 to the plaintiff's attorneys to litigate this twice in district court and once up to the 11th Circuit. So another cautionary tale. It's similar to the earlier litigation in the federal district court in California that had a similar $100,000-ish in attorney fees. The Dorsenio litigation, which was one of our cases that was also in federal district court in California, similarly went up to the 9th Circuit and went back to the district court level. So these are three cases, Belovich, Erler, and Dorsenio, that all involved over $100,000 in fee awards in cases where the amount that was in controversy originally in the cases was far, far less than that. So as these sorts of cases continue to pile up, I hope it provides sponsors with a really strong incentive to do the math. And when they're presented with a claim that they owe money under the affidavit, let's spend our time just penciling out the plain arithmetic of what's owed under the affidavit and spend the sponsor's resources paying up that relatively modest financial obligation. Because sponsors are not going to go broke. Nobody's going to go broke providing income at 125% of the federal poverty guideline. These are not high value cases. Where you do, as a sponsor, face really significant financial exposure is if you don't live up to that financial obligation, you refuse to talk about settlement when the issue is presented to you, and you go into war mode. If you go into war mode and you want to plow a bunch of resources into litigation, that's where you end up with a situation like Belovich, where we have $30,000 in damages and $125,000 in legal fees. It doesn't make sense. That's not how these cases should be resolved. So again, hopefully Belovich is one more strong datum out there that sponsors will be aware of. So when the next sponsor gets a demand letter in one of these cases, look at Belovich, do the smart thing, come to the negotiation table, and spend your time, energy, and money there rather than in years and years of federal litigation, because that's just not a winning proposition for either of the parties. Hope that's helpful. If you have general questions about claims under the Affidavit of Support, feel free to drop them into the comments. If you would like an individualized case assessment, feel free to reach out to us on our website. We do free case assessments for green card holders throughout the United States. Take care, everyone.